Hello and welcome to today's lecture on separation of powers. Dear viewers, after going through this module, we will come to know about meaning of separation of powers, rationale underlying separation of powers, need for separation of powers and relevant constitutional provisions, and finally, the role of judiciary in interpretation of doctrine of separation of powers. When we go through strict connotation of the doctrine of separation of powers, it implies that powers of the three organs of the government, that is the legislature, executive and judiciary, should be kept separate from each other. The legislature should make the laws, the executive should execute, and the judiciary should interpret them. None of these should exercise the functions of any of the remaining two organs, nor should any of these organs interfere in any way with the independent functioning of the other two organs. Theory of separation of powers, as propounded by the French political thinker Baron de Montesquieu, exercised great influence on the French legal system. This doctrine has not been recognized in its absolute rigidity in the Indian Constitution. However, it has time and again reiterated that the functions of the different branches of the government has been sufficiently demarcated in our Constitution, and consequently it can be very well said that Constitution does not contemplate assumptions by one organ of the state of the functions that essentially belong to other. The concept of separation of powers, or we can also call it as divided authority, is clearly woven in the fabric of American constitutional law. This doctrine is directly incorporated in the US Constitution. Article 1st, Section 1st of US Constitution provides that all legislative powers shall be vested in the Congress. Under Article 2nd, Section 1st, the executive powers shall be vested in the President, and the judicial powers shall be vested in the Supreme Court and in such other courts as the Congress may from time to time ordain and establish under Article 3rd, Section 1st. In theory, no organ of the government can encroach upon the powers of other. Separation of powers may therefore be a plausible constitutional doctrine, but as a matter of practice, a complete separation is never possible. Chief Justice Marshall observed in the case of Osborne versus Bank of United States that in a modern governmental setup, the legislative, the executive, and the judicial functions may overlap, and the power exercised by the three branches are potentially coextensive. Justice Frankfurter of United States Supreme Court also observed that enforcement of rigid concept of separation of powers would make modern governments impossible. Doctrine of separation of powers has an intimate impact on the growth of administrative law and administrative process. It is generally accepted that there are three main categories of governmental functions: legislative, executive, and judicial. According to theory of separation of powers, the three powers and the functions of the government in a democracy always be kept free and separate and be exercised by the three separate organs of the government. Thus, legislature cannot exercise the executive or the judicial power, the executive cannot exercise legislative or judicial power, and similarly, the judiciary cannot exercise legislative or executive powers of the government. Montesquieu in 1748 said, I quote, "When the legislative and the executive functions are united in the same person or in the same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or the state shall enact tyrannical laws to execute them in tyrannical manner. Again, there is no liberty if judicial power be not separated from that of legislative and the executive, where it joined with the legislative functions, the life and the liberty of the subject would be exposed to arbitrary control. For the judge would be the legislator. Where it joined to the executive power, the judge might behave with violence and oppression. there would be an end of everything where the same man, whether of the nobles or of the peoples, to exercise those three powers, that of enacting laws, that of executing public resolutions, and of trying the cause of individuals." Unquote. As per Wade and Phillips, separation of powers may mean three different things. One, that one organ of the government should not form part of more than one of the three organs of the government. Two, that one organ of the government should not control or intervene or interfere with the exercise of its functions by another organ. Three, that one organ of the government should not exercise the functions of other. Blackstone observed that if the legislative, executive, and judicial functions were given to one man, there will be an end to personal liberty. Dear viewers, we shall now talk about the rationale underlying separation of powers. The rationale underlying the doctrine of separation of powers is to uphold individual liberty and the rule of law. Vesting of all powers in one authority obviously promotes tyranny. The value of this doctrine lies in the fact that it seeks to preserve the human liberty by avoiding the concentration of powers in one body or one person. Justice Brandeis scientifically explained the purpose of separation of powers and said that division of powers or the separation of powers is not to promote efficiency in the administration, but to preclude the exercise of arbitrary power. He further emphasized that its purpose is not to avoid friction among various organs of the state by keeping them separate, but to protect people from the autocracy by means of inevitable friction due to distribution of powers. Therefore, the basic purpose of the doctrine is to divide the governance against itself by creating distinct centers of power so that they could prevent each other from threatening tyranny. The purpose of this doctrine of separation of powers is to have a government of law rather than official whim or will. Montesquieu emphasized that if total power of the government is divided among autonomous organs, one will act as a check over other, and in such a way liberty can survive. The logic behind the doctrine is polarity rather than strict classification, meaning thereby that the center of authority must be dispersed to avoid absolutism. Most important aspect of this doctrine is judicial independence from the administrative discretion. There is no liberty if the judicial power be not separated from the legislative and the executive. The logic behind the doctrine is that if all the power is concentrated in one and the same organ, there would arise danger that it would enact tyrannical laws, execute them in despotic manner, and interpret them in an arbitrary fashion without any external control. Merger of all these powers or the functions in one body will lead to autocracy and negation of liberty. Pointing towards political usefulness of the doctrine, Justice Chandrachud, in the case of Indira Nehru Gandhi versus Raj Narayan, observed that the doctrine of separation of powers is now widely recognized. No constitution can survive without a constitutional adherence to its fine checks and balances. Dear viewers, we shall now briefly limelight the historical background of doctrine of separation of powers. The doctrine of separation of powers has emerged in several forms at different periods. This doctrine is normally associated with French philosopher Montesquieu, but the origin of this principle can be traced back to Aristotle, who opined that government should be composed of three organs, namely deliberative, magisterial, and judicial. However, the scope of this doctrine was not worked out fully until Locke and Montesquieu elaborated this concept in 18th century. Following this principle, John Locke, James Madison wrote in the Federal Papers that the accumulation of all the powers, legislative, executive, and judiciary, in the same hands, whether of one or few or many, and whether hereditary, self-appointed or elective, may justly be pronounced the very definition of tyranny. Montesquieu gave it a basis on which modern attempts to distinguish between legislative, executive, and judicial powers is grounded. French philosopher John Bodin and British politician Locke had expressed their views about the theory of separation of powers, but it was Montesquieu who for the first time formulated this doctrine systematically, scientifically, and clearly in his book Esprit des Lois, meaning the Spirit of Laws, which was published in the year 1748. Dear students, now we shall try to understand the separation of powers and relevant constitutional provisions in the President under Article 53, Clause 1, which provides that the executive power of the Union shall vest in the President and it shall be exercised by him in accordance with the Constitution either directly or indirectly or through officers subordinate to him. Similarly, executive power of the state is vested in the Governor under Article 154, Clause 1. But so far as the legislative and the judicial powers are concerned, they are not vested in any authority. Under Article 50, one of the directives of the state policy, state is to take steps to separate judiciary from the executive in the public service of the state. But this has nothing to do with the vesting of powers. However, it's the constitutional duty of the judiciary to adjudicate the disputes between the citizens and the states intercede and the states and the centre in accordance with the constitution and the law, as was observed by the Supreme Court in the case of Kartar Singh versus State of Punjab. Chief Justice Subha Rao observed in the case of Kholak Nath versus State of Punjab that the constitution brings into existence three different constitutional entities, namely the Union, the states and the Union territories. It creates three major instruments of power, namely the legislature, the executive and the judiciary. It demarcates their jurisdiction minutely and expects them to exercise their respective powers without overstepping their limits. They should function within the spheres allotted to them. Indira Nehru Gandhi versus Raj Narayan, in this case, Chief Justice Ray observed that in Indian Constitution, there is a separation of powers in broad sense only. A rigid separation of powers as provided under US Constitution or Australian Constitution does not apply to India. The Constitution of India does not recognize the division of powers in the strict sense. It was again observed by the Honorable Supreme Court in the case of Ram Javaiya Kapoor versus State of Punjab that the Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of different parts or branches of the government have been sufficiently differentiated, and consequently it can be very well said that the Constitution cannot contemplate assumption by one organ or part of the state of the functions that essentially belong to another. Theory of separation of powers indeed broadly holds the field in our constitutional scheme. In case of Keshwananda Bharati versus State of Kerala, separation of powers came to be recognized as one of the basic features of constitution and thus cannot be altered. In the case of Asif Hamid versus State of Jammu and Kashmir, Supreme Court observed that although the doctrine of separation of powers has not been recognized under the Constitution in its absolute rigidity, but the constitutional makers have meticulously defined the functions of various organs of the state. Legislature, executive and judiciary has to function within their own spheres, demarcated under the Constitution. No organ can usurp the functions assigned to the other. Justice Bhagwati, in the case of Minerva Mills Limited versus Union of India, observed that under our Constitution, we have no rigid separation of powers as in the United States of America, but there is a broad demarcation, though having regard to the complex nature of governmental functions, certain degree of overlapping is inevitable. Dear students, Now we shall try to understand the role of judiciary in the interpretation of doctrine of separation of powers. Under Constitution of India, the executive is endowed with certain legislative powers. For instance, the ordinance making power under Article 123 and 213. It also has certain judicial powers under Article 103 and under Article 192. The legislature is also empowered to exercise certain judicial powers under Article 105 and 195. The judiciary also exercises certain legislative and executive powers under Articles 145, 146, 227 and 229. In addition, the executive exercises substantial quasi-judicial powers under several statutory provisions whereby tribunals have been set up. Parliament, the highest legislative body in the country, also exercises quasi-judicial powers in the cases of impeachment of judges under Article 124 Class 1 and Article 217 of the Constitution, and also in respect of contempt of legislators under Article 194 Class 3. So, the concept of rigid separation of powers is not strictly provided in the Indian Constitution, but we cannot say that there is no separation of powers or functions at all. Yes, there is, but it is very broad. The reason for the broad separation of powers is that concentration of powers in any one organ may destroy the fundamental premise of a democratic government to which India is pledged. Justice K. Ramaswamy observed in the case of Kartar Singh versus State of Punjab that it is a basic postulate under Indian Constitution that the legal sovereign power has been distributed between the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set by the Constitution. A landmark judgment on the separation of powers was delivered by the Apex Court in the case of I.R. Kuhilo versus State of Tamil Nadu. In this case, the court has emphasized on the importance of separation of powers and the system of checks and balances envisaged in our Constitution. It observed that for preservation of liberty and prevention of tyranny, it is absolutely essential to vest separate powers in three different organs. The court reiterated that separation of powers between legislature, executive and judiciary constitutes one of the basic features of the Constitution. It was further observed that constitutional amendments are subject to limitations, and if question of limitation is to be decided by the Parliament itself, which enacts the impugned amendment and gives that law a complete immunity, it would disturb the checks and balances in the Constitution. The authority to enact the law and decide the legality of limitations cannot vest in one organ. The validity of limitation of the rights in Part 3rd can only be examined by another independent organ, namely the judiciary. Thus, Constitution of India recognizes doctrine of separation of powers, but not in the strict sense of the term. Professor Wade writes that the objection of Montesquieu was against accumulation and monopoly rather than interaction. Montesquieu never used the word separation. Therefore, not impassable barriers and alterable frontiers, but mutual restraint in the exercise of powers by the three organs of the state is the soul of the doctrine of separation of powers. In order to conclude, we can say that under the traditional theory of separation of powers, the legislature, the judiciary and the executive enjoy separate and distinct domain. Policy making and implementation are conventionally regarded as the domain of legislature and the executive respectively, with the judiciary performing supervisory function. The Indian Constitution does envisage distinct roles for the three organs of the state. It absorbs the theory of separation of powers, but to an extent. Specific provisions of the Constitution vest in each of these organs powers and functions to be exercised in the manner laid down in the Constitution itself. But this division of powers does not carve out mutually exclusive domain. The honorable courts have recognized the differentiation of functions between the legislatures, the executive and the judiciary, and reasoned that although the Constitution did not incorporate rigid separation of powers, No organ would constitutionally assume the powers that essentially belong to other organs. Thus, the doctrine of separation of powers is acknowledged as an integral part of basic feature of Constitution of India. It's commonly agreed that all three organs of the state, that is legislature, the judiciary and the executive, are bound and subject to the provisions of Constitution which demarcates their respective powers, jurisdictions, responsibilities and relationship with one another. It's assumed that none of the organs of the state, including the judiciary, would exceed the powers as laid down by the Constitution. It's also expected that in the overall interest of the country, even though their jurisdictions are separated and demarcated, all the institutions would work in harmony and in tandem to maximize public good. In today's concept of liberalization, privatization and globalization, the doctrine of separation of powers cannot be interpreted to mean absolute division of powers in the strict sense, but community of powers exercised in the spirit of cooperation by various organs of the state in the best interest of the people. In many modern constitutions, the powers of the government cannot be kept in watertight compartments, nor can any government run on the principle of strict separation of powers. That's why the Indian Constitution has not recognized separation of powers in its absolute rigidity. With this, we conclude today's lecture on separation of powers. Hope you understand and enjoyed the same. Thank you and goodbye.